All right, we'll call to order. I want to welcome everybody to this public meeting of the Standing Committee on Economic Development and Environment. This is our clause-by-clause review of Bill 46, the Public Land Act. And I will kick things off with a prayer, so if I can ask everybody to stand, please. Lord, we thank you for this day and the many blessings we have received. We thank you for the ability to use our minds and work together to create strong and healthy communities. We thank you for looking over our constituents and all who we serve. Lord, we pray for all in our communities who are hungry, who are ill, and those who live in violence. As this meeting begins, Lord, please provide each person here with clarity of mind, creativity, compassion, integrity, and a sense of humor. Lord, give us listening ears, thoughtful words, and an open heart as we meet here today. Amen. All right. I will ask members to introduce themselves for the record, and I'll start on my left.
Good evening, Kieran Tester, member for Cam Lake.
Danny McNeely, Satu, good evening.
Kevin O'Reilly, Frame Lake.
RJ Simpson, Hay River North.
Thank you, and I am Corey Van Thyn, MLA for Yellowknife North, and the chair of the Standing Committee on Economic Development and Environment. We also have here with us this evening on my far right, Cynthia James is our clerk trainee. To my right is Michael Ball, our committee clerk. Our committee researcher is April Taylor, and our committee law clerk is Sheila McPherson. So without further ado, today the Standing Committee on Economic Development and Environment is holding a public clause-by-clause review of Bill 46, the Public Land Act. Bill 46, Public Land Act, proposes to establish new legislation that will repeal and replace the Commissioner's Land Act, which governs the administration of small amounts of land in and around some NWT communities, and the Northwest Territories Lands Act, the post-evolution mirrored legislation replacing the Federal Territorial Lands Act used to administer the majority of public land in the NWT. Establish mechanisms to allocate land through grants, sales, leases, licenses, permits, and other instruments. Establish authorities for public land administration and control, including controls and protections for the sale, occupancy, and use of land, using a range of tools such as land withdrawals, reservations, securities, inspections, and enforcement, and set out regulation-making authority specific to land administration matters such as collecting rents and royalties, recording and maintaining records, and land transactions like recreational leases or quarrying materials. Bill 46 received second reading in the Legislative Assembly on March 12, 2019, and was referred to the Standing Committee on Economic Development and Environment for review. The committee sent letters inviting input from an extensive list of stakeholders, including municipal and Indigenous governments in the Northwest Territories, as well as a number of non-governmental organizations and stakeholders. Committee traveled throughout the territory and held public hearings in Fort Smith, Katloditchi First Nation, Hay River, Fort Simpson, Fort Providence, Yellowknife, and Inuvik. The committee thanks everyone who attended these meetings or provided written submissions sharing their views on Bill 46. There are copies of the bill available at the back of the room, and I will now invite the Honourable Minister of Lands to introduce yourself and your staff for the record and proceed with any opening remarks you may have. Minister Siebert.
Thank you, Mr. Chair. I'm here to present Bill 46, Public Land Act. With me today I have Mr. Willard Hagan, Deputy Minister, Department of Lands, Ms. Melissa Bard, Manager of Legislation, and Ms. Christina Brownlee, Legislative Counsel, Department of Justice. Behind me are Ms. Kate Hearn, Assistant Deputy Minister, Planning and Coordination, Mr. Conrad Bates, Assistant Deputy Minister, Operations, Ms. Shauna Hamilton, Director of Policy, Legislation, and Communications, and my Ministerial Special Advisor, Ms. Heather Riviere, Jeremy Dixon, Senior Legislative Advisor, Lands, and Rohan Brown, Legal Counsel, Justice. The purpose of land administration legislation is to establish the rules for creating and transferring interests in public land from one party to another. Bill 46 seeks to harmonize the two existing public land administration regimes under the Northwest Territories Lands Act and the Commissioner's Land Act. The bill addresses the technical and administrative inconsistencies between the acts and consolidates them into a single legislative foundation. Public land administration legislation cuts across all sectors and all regions. By harmonizing the legislation, we can better serve our residents, attract investment, and diversify our economy. Bill 46 addresses the outdated provisions and eliminates unnecessary regulatory hurdles. Notable examples of these improvements are implementing metric measurements and removing historical provisions that restrict public land from being sold if suitable for muskrat farming. Further, Bill 46 provides enforcement authorities that are absent in the Commissioner's Land Act and will ensure our inspections and compliance program is delivered consistently across all public land. Though Bill 46 is not a silver bullet for all public land management challenges, it is the result of careful work and broad engagement, and this is an important first step to help improve land administration in the Northwest Territories. The scope of the initiative focused on addressing technical barriers to make public land administration more efficient and consistent. As the work to harmonize the two land acts progressed, they became so similar that amalgamating them made the most logical sense. It provides a strong base within a single act to further improve our public land administration regime through future regulation and policy development. Mr. Chair, Northerners need to have a consistent legislative base for public land administration to evolve and respond to local needs. Bill 46 is an important first step in that effort. I am prepared to answer any questions or comments committee members may have.
Thank you, Minister, for your opening comments, and I'll look to committee now for any comments or general questions before we get started. Mr. Testart.
Thank you, Mr. Chair, and I want to commend the department for bringing these two pieces of legislation together. We had two, for many, many, many years, we've had two separate regimes for two different types of land. This is still the state of affairs in the Yukon, and when we were first reviewing the department's plans to bring forward legislative changes to these acts, the initial plan was to keep them separate. And, we were told at that time that it's taken, Yukon's had this for decades and has made no progress on it. So the fact that we were able to pull this together in this way, and again, as the Minister said, it's not a silver bullet, but I think this gives a strong basis for the department to bring more improvements going forward and to develop the kind of policy tools we need to address the inconsistencies in land management throughout the territory. And what we heard on our consultation was not so much the applicable to the substance of the bill. It was much more around the policy decisions that arise from the bill. So the Minister and his department have a lot of work left ahead, and I know they know that. Unauthorized occupancy, equity lease issues, there's a plethora of these things, and they're a really important challenge for our communities. But I think this puts us on solid footing, and I appreciate the collaborative work that has been undertaken with committee and the department. That should be noted, and it is very much appreciated. Thank you.
Thank you, Mr. Testart. Take that as a comment. Any reply to the comment? Seeing none, comment noted. Next I have Mr. O'Reilly.
Thanks, Mr. Chair. I do want to acknowledge, I think we're going to make some significant improvements to the bill here this evening, but I'm not sure I'd characterize this as a silver bullet. I'm not even sure it's a bronze bullet. What sticks out for me on this bill is that the public was told that we were going to make changes to two separate pieces of legislation, and then all of a sudden, out of thin air, a bill is dropped into the House. Committee didn't know this either until very shortly before, where the two systems are amalgamated. I don't think in principle that's a bad thing, but can someone explain to me how we went from legislative proposals, public consultation on two bills, and then we ended up with one bill without, as I understand, any co-drafting, but I'll get to that in my next question. Thanks, Mr. Chair.
Thank you. Who cares to answer? Ms. Bard.
So the process, at the initial outset, there was a lot of work done to carefully scope what would be included in the review. And initially, the plan was, let's address these inconsistencies that are creating a lot of angst with the public and complaints about my neighbor has different rules, different lease rates, and so on. As the work progressed, and particularly when we hit the drafting phase, it became really apparent that the effort of harmonizing the two existing acts meant that we had two identical acts. And so then we took the time to review the barriers of consolidating them into one, and also the time to review the opportunity that might provide. And the biggest opportunity it provides is, for going forward, we only need to make regulation changes under one act to continue to have consistency. I don't think there was any intent to surprise anyone. I think maybe we could have communicated a bit more on that end, but certainly the scope did not change from the engagement paper all the way through to the final product in front of you today. Thank you.
Thank you. Further, Mr. O'Reilly?
Thanks, Mr. Chair. So I'd like now to have somebody explain to me, as I understand it, there was no co-drafting on this. There was no consultation with Indigenous governments in the development of this bill, and I'd like somebody to explain why that was not, why it wasn't done. Thanks, Mr. Chair.
Thank you. Ms. Bard?
Sure. So from the outset, the Intergovernmental Council was involved on the bill. So throughout several legislative initiatives, they were given the engagement paper, opportunities to comment. But as the legislative agenda progressed and IGC became quite busy, they actually specifically asked to keep the engagement on this bill minimal, given its limited scope. And they did have the opportunity to review the bill. The department considered all the comments from the IGC members that provided them, and it resulted in some improvements to the bill before it was introduced. Thank you, Mr. Chair.
Thank you. Anything further, Mr. O'Reilly?
Yes, thanks, Mr. Chair. I know this is a late point, but I don't think I've ever seen a summary of those comments. And here we are in clause by clause review, but I'd like a commitment out of the minister that he would share those with the standing committee then in the next several days. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Commitment to the minister, Minister Siebert.
I'm sorry, the request is that we share the comments received from IGC?
IGOs that took part per Ms. Bard's comments.
Yeah, that's fine.
Yeah, sure.
Thank you for the commitment, Minister. Anything further, Mr. O'Reilly?
Thanks, Mr. Chair. I know I don't have a lot of time left on the clock. There's two other items I want to ask about. The minister, in his opening remarks, talked about that this is simply just establishing rules for creating and transferring interests in public land from one party to another. I don't think it's quite that simple. This is a department that has spent a considerable amount of time developing a land use sustainability framework, and I didn't really see any of that reflected in the bill. Can someone explain to me why that was the case? Or if indeed it was incorporated into the bill, show me where in general terms. Thanks, Mr. Chair.
Thank you. Ms. Bard.
Mr. Chair, this is one of many pieces of legislation that the department uses to carry out its responsibilities. The land use and sustainability framework that was referred to is intended to guide all departments within the GNWT. It certainly guides our department and its many functions under multiple pieces of legislation. This bill and the two current pieces of legislation are very much the transactional piece or the final piece of broader land management decisions. And you generally see things implemented or applied through this act, even though the decision and the framework functions outside of the act.
Thank you. Anything further, Mr. O'Reilly?
Thanks, Mr. Chair. Well, without getting into a debate, I think we're going to talk a little bit more about the how and why land should be administered, and we're going to get to that. But my last question is, with regard to regulation making, moving forward. What is the role for Indigenous governments and indeed the public in the development of regulations under this bill if it's passed? Thanks, Mr. Chair.
Thank you. Ms. Bard?
So through regulations, the department intends to continue to engage, like it engages on all of its initiatives, not just regulation, but whether it's a policy change or a traditional cabins or, many of the rights-based or other initiatives we have in the department, we broadly engage on. We will be broadly engaging on regulations, and we will also be engaging with our Indigenous government partners. Thank you.
Right, thank you. Mr. O'Reilly, I have to move on. Next, I have Mr. McNeely.
Thank you, Mr. Chair. I'm very glad that you've, Ms. Bard, you have made reference to engagements. They're still coming to the issue of lands. It doesn't matter which community you're talking to, more so in the smaller communities. The concept of band lands versus my lands, private lands, is still out there without any real detail of education or consultation. So I'm glad through your regulatory phase there'll be some education and consultation in that area. It clears the air for what the land tenures are within each community. Even to some degree, you ask some individuals within the municipal governance bodies, what's the difference between your block land transfer and your municipal boundary? They'll shrug their shoulders and say, well, I'll have to get back to you. So that's just one of many examples. But going back to the inherited responsibilities which incorporated the department from devolution, looking back and just keeping things simple as we move along here, I'm glad we're at this point that we've got a department. We've simplified things. And to me, it's only sound, prudent management that you bring two apples together and make one. Government is confusing at best for the people it represents. So we don't have to make it more confusing. It makes a lot of sense to bring both acts together and have one, rather than referring to two different acts, downtown Toledo, for example. So I look forward to our conclusion and progress on a post-devolution environment. Thank you.
Thank you, Mr. McNeely. Further general comments, questions from committee? Mr. Nakamayak.
Thank you, Mr. Chair. I missed the minister's opening remarks, but I believe that there's an administration part of this bill that needs to move forward, and I've sat along some individuals and some committees and some ministers who strongly believe that moving forward with this, it'll benefit communities. And I think if you look around the territory, you look at municipalities, and sometimes there's a lack of capacity to when it comes to lands and the transfer. Sometimes look at the Inuvik-Tuk Highway. The amount of time it's maybe still taking time to transfer some land to the GLDT from the ILA. I think this is a good education tool, and I think having the administration part of this moving forward is complete. Some people say if you don't have land in the Northwest Territories, you don't have nothing, but that's not the case. I think I'd just like to thank the minister and his team for the work they're doing on this. Thank you, Mr. Chair.
Thank you, Mr. Nakamayak. If there's nothing further, does the committee agree to conduct a clause-by-clause review of Bill 46, Public Land Act?
Yes.
Thank you. Members, we will defer the title of the bill until the end and begin with consideration of the clauses. There are 80 clauses in the bill. Where possible, we will group the clauses. So I ask that you please turn to page 6 of the bill. Clause 1 to 5. Committee agree? Thank you. Clause, one moment. Clause 1 to 5. Mr. O'Reilly.
Thanks, Mr. Chair. Can someone tell me what the purpose of Section 5 is all about? Sorry, it's the next clause 6, pardon me.
Okay, sorry. Repeat. Clause 1 to 5, committee agree? Thank you. Clause 6 to 7, Mr. O'Reilly.
Thanks, Mr. Chair. Can someone tell me what the purpose of Clause 6 is all about? We're also in the process of developing a new Mineral Resources Act, and this provision would seem to create a parallel, or at least enable the creation of a parallel system of mining rights disposition under the Public Land Act. Thanks, Mr. Chair.
Thank you. Minister Siebert?
So I understand it's the existing authority for mineral rights disposition? Okay, thank you.
Anything further, Mr. O'Reilly?
Well, that was, I think, the briefest response I've ever had, but, so is there still the potential then for a parallel system if the Mineral Resources Act proceeds in its current form with this provision in this bill? Thanks, Mr. Chair.
Thank you. Ms. Bard?
Section 6 is currently in the Northwest Territories Lands Act as Section 10, and this is the current authority for the mineral rights regime in the Northwest Territories. The mining regulations, the coal regulations, the dredging regulations are all currently under the Northwest Territories Lands Act. So this authority that you see in Section 6 is the same as what's in the current Northwest Territories Land Act, and it's been carried over here not to create a parallel regime, but so that the existing regime can continue until and if MRA comes into force.
Thank you. Further, Mr. O'Reilly?
Thanks, Mr. Chair. So I guess this may be a question that I would like to ask our law clerk.
Please go ahead.
Section 62 of the bill, is this what enables, or is that sort of the transitional provision in the bill that allows for the mining regulations to sort of be transferred over from the NWT Lands Act to this bill?
Thank you.
Thank you.
Ms. McPherson?
That is correct. That is correct, Mr. Chairman. I can also indicate, having reviewed the Mineral Resources Act, that there are transitional provisions that are being contemplated for Bill 34 that will link into this bill so as to ensure that there is not a parallel regime in the Northwest Territories.
Thank you. Anything further, Mr. O'Reilly?
Yeah, thanks, Mr. Chair. So what happens when the Mineral Resources Act is passed? Does it, sorry, I guess this is going to be a question again for the law clerk. I don't need to go to our friends here. What is going to prevail here? Is it going to be this bill if it's passed and or the Mineral Resources Act? Or I guess it depends on when they come into force. This is a little bit more than a little bit confusing. Thanks, Mr. Chair.
Thank you. Ms. McPherson?
Thank you, Mr. Chairman. This bill will continue the regulations under the Lands Act. The real issue will be when the Mineral Rights Act not comes into force, not when it is passed, but when it comes into force, and in particular the provisions of the Mineral Rights Act that deal with the disposition of minerals. And we'll be dealing with that particular issue under the Mineral Resources Act likely tomorrow night.
Thank you. Anything further, Mr. O'Reilly? Nothing further. Clauses 6 to 7. Committee agree? Agreed. Thank you. Clause 8, Mr. Nakamayak.
Thank you, Mr. Chair. I move that Clause 8 of Bill 46 be amended by deleting subclause brackets 1 and substituting the following. The minister may, in accordance with the regulations, require that an applicant or a disposition, the holder of a disposition, or a prospective assignee or transferee of a disposition under this Act provide and maintain security with the minister in an amount and manner that the minister determines to be sufficient to protect the public interest. Thank you, Mr. Chair.
Thank you. The motion is in order to the motion. Mr. Testart.
Yeah, thank you, Mr. Chair. So I think it's always helpful if committee explains where we're coming from on some of these amendments that we're bringing forward. So in this case, the way the Act currently reads is the substantive difference between this amendment and the Act is that securities will be maintained in a form and amount determined with accordance with the regulations. So the big change here is that the security needs to be sufficient to protect the public's interest. And committee felt that that was a much stronger statement to govern security requirements here. I don't think it's as clear when it's just in accordance with the regulations, because those regulations could potentially set securities very low or very high without any clarity in law. So this clarifies that the disposition or the security needs to be sufficient to protect the public from any potential harm, and I think it's an excellent improvement over the original wording of the bill. Thank you.
Thank you. To the motion? Mr. O'Reilly.
Yeah, thanks, Mr. Chair. I too support this motion. It does put in a little bit of a test here in terms of the minister's ability and duty to get financial security, and that it will be required to be done in the public interest. So I support this. I do have another issue that I'll raise when we're finished with this motion. Thanks, Mr. Chair.
Thank you. To the motion?
Question.
Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes, we concur.
Thank you. The minister concurs with this amendment. Mr. O'Reilly.
Thanks, Mr. Chair. Just before we get to the next motion, I'd like to ask the minister for some clarification around why there's no requirements for mandatory security in the bill as drafted, which is really rolling back the provision that's found in the Commissioner's Land Act for commercial and industrial land uses. So why is the minister doing this? Thanks, Mr. Chair.
Thank you. Minister Siebert.
Yeah, we had concerns about this issue. The a mandatory securities requirement for all commercial and industrial dispositions would include for any type of business, such as greenhouses, agriculture, tourism, and small-scale businesses. This could create significant barriers to economic diversification, job creation, and efficient land administration. This requirement also seems to assume that all improvements to land are a liability, which in most cases is not true. Development land is an asset that could be sold if abandoned. Mines are often used to justify mandatory securities, but mines are designed from the outset, or usually designed from the outset to close and require significant restoration to the land. That is not how most businesses operate. We also looked at other jurisdictions, and British Columbia and Alberta are permissive, and the other provinces are silent on this issue. So those are some of the reasons that we thought that mandatory securities requirement went too far. Thank you.
Thank you, Minister. Further, Mr. O'Reilly.
Thanks, Mr. Chair. So I think it's important to recognize that the minister's authority or to request financial security is even in the section as list here in the bill, as well as in the Commissioner's Land Act, is all determined in accordance with regulations. So the minister has the ability by regulation to prescribe thresholds or limits, even on the sort of activities that he described. So even though it may be mandatory, that's tempered by whatever could be put into regulations. So I'm still trying to understand why the department, why the minister is not willing to, what this is really about is rolling back a provision that's already been carefully thought through and is the result of a lot of work on the part of a previous standing committee, the public, and the $23 million liability that we have down the road, assumed as a result of Giant Mine. So I guess I'm trying to understand the ministerial discretion that's contained in here. That's not sufficient to do the sort of things that the minister has outlined? Thanks, Mr. Chair.
Thank you. Minister Siebert.
Permissive language is used in Bill 46. Section 8 is not written to give the minister case-by-case authority to require securities for proposed developments. Instead, it gives the minister via regulations the ability to require securities for all types of dispositions that have risk. And I happened to look at the Commissioners Land Act, Section 3.1, I think that 3.1 in brackets 1, and just to see how close it was to the proposed or these clauses. And it read, it is a condition of the lease of commissioner's land for a commercial or industrial use that security determined in accordance with the regulations be posted for restoration of land. So it referred to leases.
Thank you. Anything further, Mr. O'Reilly? Thanks,
Mr. Chair. I guess I'd like to ask a question of our law clerk then. Is it possible in the wording that even in Section 8.1 as worded here, that the minister has the ability to set thresholds for different types of land uses and so on, that might require or may require financial security? Is that the case with the way this has been drafted right now? Thanks, Mr. Chair.
Thank you. Ms. McPherson.
It occurs to me, Mr. Chairman, that Clause 8.1, as currently before the committee, is broad enough to allow the minister to designate the rules around the provision of securities, but it would be in regulation.
Thank you. Anything further, Mr. O'Reilly?
Thanks, Mr. Chair. Yeah, as I said, I think I really view this as a very significant rollback that is not in the public interest. And I'm going to bring forward a motion in the next item of business that will attempt to plug this rollback that I think is completely unnecessary and not based on the experience that we have from down the road here, the liability that this government has assumed because of poor financial security management. Thanks, Mr. Chair.
Okay, thank you. Anything further? Seeing nothing, then I go back to that, Clause 8. Mr. O'Reilly.
Thanks, Mr. Chair. I move that Clause 8 of Bill 46 be amended, A, by adding the following after subclause 1.1, notwithstanding subsection 1, the minister shall, in accordance with the regulations, require that an applicant for, holder of, or prospective assignee or transferee of a disposition for a commercial or industrial use provide and maintain security with the minister in an amount and manner that the minister determines to be sufficient to protect the public interest. B, in subclause 2, by striking out to which this section applies and substituting for which security is required under subsection 1 or 1.1. C, in subclause 3, by striking out subsection 1 and substituting subsection 1 or 1.1. D, in subclass 5, by striking out to which this section applies and substituting for which security is required under subsection 1 or 1.1. And E, in that portion of subclause 6, preceding paragraph A, by striking out subsection 1 and substituting subsection 1 or 1.1. Thank you, Mr. Chair.
Thank you. The motion is in order. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. So that was a lot of words to basically say that committee is interested in bringing back into this bill the kind of provision that is already contained in the existing Commissioner's Land Act, so that financial security would be mandatory for commercial or industrial use, still subject to whatever regulations the minister may wish to bring forward. So that's where the idea of thresholds could be brought in to deal with some of the issues that the minister raised. But the idea is to provide some confidence to the, some reassurance to the public that we're not going to have another reoccurrence like we did have down the road with the giant mine. And that this government will require financial security for commercial and industrial users once they exceed whatever thresholds the minister might like to put in place. Thanks, Mr. Chair.
Thank you. To the motion? To the motion. Question has been called. All those in favor? Raise your hands high, please. All those in favor, all those opposed? Okay. The motion carries. Does the minister concur with this amendment?
No, we do not.
The minister does not concur with this amendment. The amendment will not take effect as a result. Committee to Clause 8. Does committee, to Clause 8, does committee agree? Mr. McNeely?
Thank you, Mr. Chair. I move that subclause 8, brackets 5 of Bill 46 be amended by striking out brackets to the satisfaction of the minister and substituting brackets in accordance with the regulations. Thank you, Mr. Chair.
Thank you, Mr. McNeely. The motion is in order. To the motion. Mr. O'Reilly.
Thanks, Mr. Chair. Once again, I guess I'd like to explain to the public what this is all about. So the current section 8.5 of the bill says that once a disposition is finished or terminated, it's to be returned to the minister and it's to be restored. Right now it says to the satisfaction of the minister, so we're not quite sure what that really means. We'd rather are suggesting that that should actually be set out in regulations, which would provide a little bit more rigor, and maybe even if we're lucky, an opportunity for the public to comment, so that it's not at the total discretion of the minister. So I think this is an improvement, and we look forward to the minister bringing in regulations that will protect the public interest. Thank you, Mr. Chair.
Thank you. To the motion. To the motion. Question has been called. All those in favor? Thank you. All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
Thank you, Minister. The minister concurs with this amendment. Committee to Clause 8 as amended. Does committee agree?
Agreed.
Thank you, committee. Committee, Clauses 9 to 12. Committee agree? Committee Clause 13. Mr. Nakamayak.
Thank you, Mr. Chair. Mr. Chair, I move that paragraph 13, bracket C of Bill 46 be deleted and the following substituted. Bracket C, to the boundary line between the Northwest Territories and any of Nunavut, Yukon, Alberta, British Columbia, or Saskatchewan. Thank you, Mr. Chair.
Thank you, Mr. Nakamayak. The motion is in order. To the motion. Question has been called. Oh, sorry, did you want to speak to that? To the motion, Mr. Testart.
Or did you want to?
Yeah.
Sorry, one moment. To the motion, Mr. Nakamayak.
Yeah, thank you, Mr. Chair. For the sake of effectiveness and time, I think everything's laid out there on this. Thank you, Mr. Chair.
Thank you. To the motion, Mr. Testart.
Okay, thank you, Mr. Chair. I'm not so certain. So the difference between this and the original text of the amendment is the original text lays out a very confusing kind of state of affairs with boundary lines, and this improves readability of the section. So although not crucial, it is a change from what's currently in there, and again, committee likes to explain these changes. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes, we concur.
The minister concurs with this amendment. Thank you, Minister. Committee to Clause 13 as amended. Does committee agree? Agreed. Thank you. Committee to Clauses 14 through 20. Does committee agree? Clauses 21 and 22. Committee agree? Agreed. Clause 23. Mr. McNeely.
Thank you, Mr. Chair. I move that subclause 23 brackets 5 of Bill 46 be amended by striking out brackets designed to be used and being used brackets and substituting brackets being used. Thank you, Mr. Chair.
Thank you, Mr. McNeely. The motion is in order. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. So what this is about is an inspector under the bill can enter or shall not enter any place designed to be used and being used as a dwelling place. So the committee felt that that was going too far and that it might actually lead to inspectors not being able to go into some buildings where they perhaps should be. So this is about clarifying that inspectors can go into buildings as long as they're not being used as a residence in some way, as a dwelling place. So I think it's a clear definition, and we'll make sure that inspectors have the ability and the authority to do what they need to do. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
Thank you. The minister concurs with this amendment. Committee, to Clause 23 as amended. Does committee agree? Thank you. Committee, clauses 24 to 30, committee agree? Clauses 31 to 35, committee agree? Clauses 36 to 40, committee agree? Clauses 41 to 45, committee agree? Clauses 46 to 50, committee agree? Clauses 51 to 55, committee agree? Clauses 56 to 58, committee agree? Clause 59, Mr. Testart.
Thank you, Mr. Chair. I move that Bill 46 be amended by adding the following after paragraph 59, brackets F1, respecting the provision of notice to municipal corporations under section 12.1. Thank you, Mr. Chair.
Thank you, Mr. Testart. The motion is in order. To the motion. Mr. O'Reilly.
Thanks, Mr. Chair. This is a little bit complicated, but this will allow the minister to develop regulations around how to provide notice to municipal corporations. Section 12.1, we actually haven't dealt with that quite yet. We're going to come to it, but this would be a new requirement in the bill for notice to be given to municipal governments about significant land transactions within their boundaries. And this was something that was requested of us by municipal governments, so that's why we want to make sure the minister has the proper regulation-making authority to enable this to happen in a reasonable way. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. To the motion?
Question.
Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes, we do.
The minister concurs with this amendment. Thank you, Minister. Committee, to Clause 59 as amended. Mr. O'Reilly.
Thanks, Mr. Chair. I move that Bill 46 be amended by adding the following after paragraph 59G, prescribing exempt dispositions for the purpose of Section 6.1. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion. Mr. O'Reilly.
Yeah, this is tying back to this bill serving as the instrument for disposition of mining rights as well. So this gives, as I believe it, the minister the authority to say that some lands are exempt from having the mineral rights disposed of. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. To the motion.
Question.
Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes. Yes, we do.
Thank you. The minister concurs with this amendment. Sorry, committee, to the motion, committee agree, or sorry, to the clause, sorry, where am I now?
59 as amended.
Yeah, sorry, to Clause 59 as amended. Does committee agree?
Agreed.
Thank you, Mr. Chair. I move that Bill 46 be amended by adding the following after 61 brackets F, brackets F.1 bracket, respecting the restoration of land to which Section 8 applies, including the standard to which the land must be restored. Thank you, Mr. Chair.
Thank you, Mr. McNeely. The motion is in order. To the motion, Mr. Testart.
Thank you, Mr. Chair. This motion allows regulations respecting the standard to which land must be restored to be put forward by the department, and will allow for some guidelines to be built around restoration after a lease or disposition of land is terminated by a party. And I think it's a necessary feature of the regulations and an improvement over what's currently there. Thank you, Mr. Chair.
Thank you. To the motion, Mr. O'Reilly.
Yeah, thanks, Mr. Chair. Earlier in our motions, we took away that this wasn't just to the satisfaction of the minister. We said that it had to be done by regulation, so this is inserting the authority for regulations to be made. And just looking at this, it's kind of a curious placement. This is in a section where it's going to be the commissioner and executive council making regulations around this rather than the minister, but maybe everybody in cabinet has a real interest in restoring the land. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. To the motion. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes, we concur.
The minister concurs with this amendment. Thank you, Minister. Committee, to clause 61 as amended, does committee agree?
Agreed.
Thank you, committee. To clause 62 through 64, does committee agree? Thank you. Clause 65, Mr. Nakamayak.
Thank you, Mr. Chair. I move that Bill 46 be amended in each of the subclauses 65 brackets 1 and brackets 2 by striking out land that become public land and substituting land that becomes public land. Thank you, Mr. Chair.
Thank you, Mr. Nakamayak. The motion is in order. To the motion, Mr. Testart.
This motion is to address a drafting error in the language used around land that becomes public land rather than lands that become public land. So there were a few instances of that as the merger of the two legislation came forward. So this is one of those, and there'll be more coming along just to make sure the act reads consistently. Thank you, Mr. Chair.
Thank you, Mr. Testart. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
Thank you. The minister concurs with this amendment. Committee, to clause 65 as amended, does committee agree?
Agreed.
Thank you. Clause 66, does committee agree? Mr. Simpson.
Thank you, Mr. Chair. I move that clause 66 of Bill 46 be amended by striking out land under that act become public land and substituting land under that act becomes public land. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion is in order. To the motion.
Question.
Mr. Simpson.
When you amalgamate a Land Act and a Lands Act, you wind up with some of these strange situations when you just copy and paste. So it's just a drafting error. Thank you.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
Thank you. The minister concurs with this amendment. Committee, to clause 66 as amended, does committee agree? Thank you. Clause 67, does committee agree? Mr. Testart.
Thank you, Mr. Chair. I move that clause 67 of Bill 46 be amended by striking out certain federal real property under the act become public land and substituting certain federal real property under the act becomes public land. Thank you, Mr. Chair.
Thank you, Mr. Testart. The motion is in order. To the motion. Mr. Testart.
Yet another drafting error, and I think this is the last one to be corrected. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
The minister concurs with this amendment. Thank you, Minister. Committee, to clause 67 as amended, does committee agree? Thank you, committee. Clauses 68 to 70, committee agree? Clauses 71 to 75, committee agree? Clauses 76 to 80, committee agree? All right, committee, oh, sorry, I'll go back. Clauses 76 to 80. Mr. O'Reilly.
Thanks, Mr. Chair. It's becoming a bad habit of mine, but I'd like to know what the intentions are in terms of when this bill is going to come into force. Thanks. Should it pass in the House? Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Minister Siebert. Ms. Bard.
The act will come into force by order. The intent is to address some additional harmonization in regulations and start with kind of a phase one and essential harmonization, and then continue to advance reg work beyond that. But the plan, subject to the priorities of the next assembly and resourcing, the plan is to harmonize regs and bring into force within 12 to 24 months.
Excuse me. Thank you. Further, Mr. O'Reilly.
Thanks, Mr. Chair. So, yeah, how is that going to be communicated to people that have an interest in this bill once it becomes law? How's that information going to be communicated to people? Thanks, Mr. Chair.
Thank you. Ms. Baird. Bard, sorry.
The department will be engaging the public and all of its stakeholders in regards to regulation work. So through the department website and its engagement practices, it will be making that very clear. Thank you.
Thank you. Anything further, Mr. O'Reilly?
Thanks, Mr. Chair. Well, it's clear that the department's done some thinking about this because they've got a time estimate, 12 to 24 months. I raised this in the House in the context of the oil and gas bills, and what I'd like to get is a commitment out of the minister that they can put together some information about how this is going to roll out for this assembly so that we know what's happening, but more importantly for the public. You know, there's been a lot of concern and issues around land administration, and we've hired 6 people to tidy up equity leases and all of this kind of thing. Presumably, this will now give the department some ability to fix some of those issues. So can I get a commitment out of the minister that he can prepare some kind of an implementation plan and share that with this assembly and the public? Thanks, Mr. Chair.
Thank you. Commitment to the minister, Minister Siebert.
Yes, we can commit to that.
Thank you. Appreciate the commitment. Anything further, Mr. O'Reilly?
No, thanks.
Committee to clause 76 to 80. Does committee agree? Thank you. Committee, that concludes the clauses. I move to Mr. O'Reilly.
Thanks, Mr. Chair. I'm still trying to figure out this process, but now we're actually at the point where we're looking at adding some new clauses to the bill that aren't already there. So I move that Bill 46 be amended by adding the following after Clause 2.1. The purpose of this act is to provide a framework for the administration of public land in the Northwest Territories in accordance with the following principles. A, administration of public land should be efficient and effective. B, administration of public land should be done in a responsible manner on behalf of the people of the Northwest Territories. C, administration of public land should take into account, where appropriate, the interests and concerns of stakeholders, Indigenous governments and organizations, municipalities, and affected governments. D, administration of public land should reflect balanced decision-making with respect to the grant or disposition of public land. E, administration of public land should provide for regular and transparent disclosure of information to the public. F, administration of public land should encourage responsible stewardship of public land. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly. The motion is in order. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. So this committee and some of the other committee work that I've been involved in, a lot of time and effort has gone into developing either preambles for the bills or some kind of a purpose statement. And let's just say this bill really didn't have a lot in that regard. I don't even think there was a purpose statement in this bill, which is kind of weird. So committee put its mind to this. There were submissions that the committee received from a variety of stakeholders suggesting this, including First Nations governments. Committee worked to prepare a list. I think it's fair to say we went back and forth with the department several times over this. My preference would have been that this should, that appears in all of these items, would probably should be replaced with shall, but I can live with this, at least for now, and see how it rolls out. But this incorporates a lot of ideas out of your land use sustainability framework that you guys already have developed. So I'm a bit surprised, as I said earlier, that this was not incorporated in some manner into the bill before it landed on our desks. So this is our attempt to try to ensure that there is a set of principles or purpose for the bill and in terms of how lands are going to be administered and managed moving forward. Thanks, Mr. Chair.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
The minister concurs with this amendment. Thank you, Minister. Committee, to new clause 2.1, does committee agree? Agree. Thank you. MLA, or Mr. Simpson.
Thank you, Mr. Chair. Mr. Chair, I move that Bill 46 be amended by adding the following after Clause 6, 6.1. 1. The minister shall make available in a timely manner on the website maintained by the department responsible for the administration of this act, A, information in respect of any disposition of land under Section 5 other than those excluded by regulation, B, information in respect of any disposition of mining rights under Section 6. C, information in respect of any requirement to provide security, any reassessment of security, or any application of security under Section 8. D, information in respect of any withdrawal of public land under Section 10. And E, information in respect of any reservation of public land under Section 11 or 12. 2. Subsection 1 does not apply to any grant or disposition that has been registered in accordance with the requirements of the Land Titles Act. Thank you, Mr. Chair.
Thank you. Thank you. Mr. Simpson, if I can, I'll ask you to reread Part A of that, just because there was a bit of a misread for the record. Thank you, Mr. Simpson.
Just Part A?
Just Part A.
A, information in respect of any disposition of public land under Section 5 other than those excluded by regulation. Thank you, Mr. Chair.
Thank you, Mr. Simpson, for being clear. Appreciate that. The motion is in order. To the motion?
Question.
Or Mr. O'Reilly?
Look, this is a significant improvement in the bill. I think we should talk about it a little bit. This is going to require that the department establish a rudimentary public registry. There is something that, through the Land Titles Act, but this is a significant improvement. And we've been doing this with a number of the other resource management and environmental legislation that have come through this committee. So this is an improvement. And I do support this. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. To the motion, Mr. Testar.
Yeah, thank you, Mr. Chair. And as my colleague pointed out, there are a number of bills where similar public-facing registries or information sources have been required by statute. And I think because we've had the benefit of looking at a suite of bills that all kind of do similar things, I just want to clarify that my imagination for this process would be not 5 different repositories of information online for each different act, but a single central repository where all this stuff could be gathered. And the drafting was intentional to do that. And this is something that a whole of government approach could build, not just the Department of Lands or the Department of ENR. And I think that would greatly improve the public's access to a lot of the information that's going to be generated by this amendment, should it carry. Thank you.
Thank you. To the motion?
Question.
Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
Thank you. The minister concurs with this amendment. Committee to new clause 6.1. Does committee agree?
Agreed.
Thank you, committee. Mr. Nakamayak.
Thank you, Mr. Chair. I move that Bill 46 be amended by adding the following after subclause 12. 12.1, the minister shall, in accordance with the regulations, provide notice to a municipal corporation of any of the following if they will occur within or adjacent to the boundaries of the municipality. A grant of public land or under Section 5. B, a disposition by way of lease or quarry permit under Section 5 or 6. C, any withdrawal of public land under Section 10 after the registration of the withdrawal. D, any reservation of public land under Section 11 or 12. Thank you, Mr. Chair.
Thank you. To the motion, the motion is in order. To the motion, Mr. Testart.
Thank you, Mr. Chair. And this is another significant issue for the committee, which was around ensuring that municipalities are given proper notice when it comes to land that is adjacent to the municipal boundaries. And we've seen this in a couple other bills, but in this, to be specific, when public land is transferred, this provision will ensure that there is notice provided to the municipality. So that way, there's an opportunity for them to at least know what's going on in their backyard, so to speak. And we have, of course, seen a number of issues over the years where the uncertainty around tenure and the disposition of certain rights, especially around quarrying rights, have put municipalities on the back foot. So this is another effort of committee to recognize the important contributions local community governments make in our lives in the north, and how important our small and all our communities are, and that they should be at the table too when considering these important decisions. Thank you.
Thank you. To the motion, Mr. Nakamayak.
Yeah, thank you, Mr. Chair. Mr. Chair, coming from a signed land claims agreement, all of this already occurs within the Nunavut, and I'm sure it does with the Gwich'in and other land claims agreements. I think as we move forward, I'm noticing that we're kind of narrowing the margins for the departments and Indigenous governments to work. I believe we always need to give them the space and the time that they need to work within regulations and you know, what the scope of whatever it may be, whether it's oil and gas, mining, or other types of development. Thank you, Mr. Chair.
Thank you. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, we actually heard about this issue while we were in Inuvik. We had the senior administrative officer, the mayor, I believe, at that public hearing, and they talked about problems in the Inuvik area with regard to land dispositions and zoning and control of development and so on. So they indicated to us that they would like to have the ability to get some form of notice about things going on within their boundaries. So maybe it is happening in other parts of the Northwest Territories, but it certainly wasn't happening in Inuvik. That's what we heard. So this is just about making sure that we treat our community governments, I think, with the respect that they deserve, and ensuring that they're informed of land changes within their boundaries, so that they can properly do their planning and exercise their jurisdiction. So I do support this, and I do think it's an important improvement in the bill. And of course, we're going to try to do something similar with this in terms of the Mineral Resources Act. So that'll be an interesting debate and discussion for tomorrow night. But I'm glad that the Department of Lands saw that this was something that is worthwhile, and I look forward to the minister's concurrence. Thank you, Mr. Chair.
Thank you. To the motion?
Question.
Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Jason, yes, I concur.
The minister concurs with this amendment. Thank you, minister. Committee to new clause 12.1. Does committee agree?
Agreed.
Mr. Simpson.
Thank you, Mr. Chair. Mr. Chair, I move that Bill 46 be amended by adding the following immediately before Clause 53. 52.11. The minister shall, within 4 months after the end of each fiscal year, cause to be prepared an annual report with respect to the administration of this act during that fiscal year, including A, the number of grants under subsection 5.1, B, the number and type of dispositions under subsection 5.1. C, the number of dispositions under paragraph 6.1a. D, the royalties received under paragraph 6.1b. E, a summary of security managed during the fiscal year under section 8, including 1, any assessment of security under subsection 8.1, 2, any reassessments of security under subsection 8.3, and 3, any application of security under subsection 8.6. F, any withdrawals of public land under section 10. G, any reservations of public land under section 11 or 12. And H, a summary of inspection and enforcement activities carried out during the fiscal year, including 1, any notices of violation issued under section 38 and the penalties assessed. 2, any reviews requested under section 43. 3, any correction or cancellation under section 44. 4, any reviews conducted by the minister under section 46. And 5, the recovery of any penalties under section 50. 2, the minister shall cause the annual report prepared under subsection 1 to be laid before the Legislative Assembly at the earliest opportunity. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion is in order. To the motion. Mr. Testart.
I think my colleague reading the amendment makes it clear what's contained in that report at length, but this is just to require the minister to table an annual report in the Legislative Assembly that details all the decision points in this bill. So anything that this bill is enabling in the Northwest Territories, that's going to be rolled up in this report where applicable and brought to bear in the Legislative Assembly, and interested members of the public can see how this land is, how the Act is being administered and the decisions made through it. And this is an important part of the public's right to know, and I'm glad we were able to collaborate to bring this forward. Thank you, Mr. Chair.
Thank you. To the motion. To the motion.
Question.
Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Yes.
Thank you. The minister concurs with the amendment. Committee to new clause 52.1. Does committee agree? Thank you. Next, Mr. Testart.
Thank you, Mr. Chair. I move that Bill 46 be amended by adding the following after Clause 61, 61.1.1. A copy of each regulation that the Commissioner, on the recommendation of the Minister or the Commissioner and Executive Council, as the case may be, proposes to make under this Act shall be published in the Northwest Territories Gazette, and a reasonable opportunity shall be afforded to interested persons to make representations to the Minister in respect of the proposed regulations. 2, no proposed regulation need be published more than once under subsection 1, whether or not it is altered or amended after such publication as a result of representations made by interested persons as provided in that subsection. 3, subsection 1 does not apply to any regulation continued under section 62 of this Act. Thank you, Mr. Chair.
Thank you. The motion is in order. To the motion. Mr. Testart.
Thank you, Mr. Chair. And one thing we've learned through many weeks of consultation is there's a high degree of interest in the regulatory side of these bills. A lot of these bills or these new laws around, in respect to the devolution agenda, are frameworks for regulations to really make them real. And we have heard plenty of submissions from the public, from industry, from Indigenous partner governments that they would like a hand in how those regulations are developed. Now, we understand that there's some hesitancy to hand the pen over to someone from outside of government, and there's good sense to leave regulation making or regulation writing within the powers of the executive branch of government. That being said, however, there is precedent in the Northwest Territories through the Petroleum Products Resources Act where this exact section exists, where regulations are gazetted and a period of public notice is provided. The Mackenzie Valley Resource Management Act, which is a paramount regulatory regime for the Northwest Territories and many parts of the Northwest Territories, that has a requirement that any regulations require consultation from Indigenous governments. So we have two leading examples. One, legislation operated by our own government, where this exact motion is required, and 2, a much more extensive motion contained in the MVRMA. And I think this is a really good precedent to set moving forward. Again, when the government is bringing forward laws that very clearly make space for extensive regulations, there's got to be more to it than just letting the government go off and write those regulations and following their own processes. So this at least ensures that the public gets a spotlight on any new regulations that come forward, and they can be assessed, addressed, questions can be raised, all of that kind of stuff. And one thing we've heard very clearly is it can't just be one party, it can't just be the Indigenous governments. They certainly have a larger role to play in respect to the Intergovernmental Council and the Intergovernmental Agreement, but there's also a need for industry and for civil society to get involved as well. So I think this strikes a necessary balance of opening up the regulatory process, at least to public notice and comment, and that's a very fair balance to strike. We're not handing the pen away from government, but we are allowing the public to get a crack at what's being proposed by government, and that's a very important distinction. Thank you, Mr. Chair.
Thank you. To the motion, Mr. Nakamayak.
Yeah, thank you, Mr. Chair. I look at this and I see towards the bottom of the top paragraph, afforded to interested persons. I think this looks like a side door for NGOs to come in and start drafting, Mr. Chair. And with all due respect, Indigenous governments worked hard for their land to get their land claims agreements signed, and there are still some that are working very hard, 20-some years. I think this is kind of a kick or a shot to somebody who's been working so hard for their Indigenous government for a long time. We know that Indigenous governments don't hold the pen sometimes. It's the governments that are drafting these. So we have a part to play. There's a part for everyone to play. Indigenous governments make their own policies all the time, not government. So in this case, I do not support this. I think this is as I said before, this is a side door for NGOs to come in, and I think it's an offense to Indigenous governments who negotiate their land claims for many years and so ongoing. So thank you, Mr. Chair.
Thank you. Next I have Mr. O'Reilly.
Thanks, Mr. Chair. I guess I just need to correct a few things that from the honourable member from Nunakput just said. This is the NGOs are not even identified in this. This is to give interested persons. Persons has a legal definition. It can include a corporation, could include business, industry, it could include individual residents. So this is about making it a fair process for anyone who might have an interest to comment on draft regulations. So I really think that that's a mischaracterization of this clause or this motion. And I would furthermore point out that the bill itself, there's a non-derogation clause in here that this cannot take away from Indigenous rights in any way. So I think there's some further misinformation there. But I do recognize that through the devolution agreement and the Intergovernmental Council, there is a special relationship in terms of co-drafting. This does not address the issue of co-drafting. This is about public notice to anyone. This does not take away from the co-drafting process that is used on some bills. It wasn't used on this one. So I just felt the need to correct that, Mr. Chair. But moving on to the motion itself, what this does is adopt, as my colleagues from Cam Lake said, language that already exists in our own legislation, in the Petroleum Resources Act and in the Oil and Gas Operations Act. Just that's the exact wording that's been inserted here to allow for the public to receive notice through the Gazette of regulations and for them to comment on it, be given a reasonable opportunity to comment on it. Thank goodness the federal government had the foresight to do this in its bills, but in our Made in the North approach, we don't have that. There's nothing. We've got a commitment from a staff person, with all due respect, with the Department of Lands, that some kind of engagement is going to carry forward on the development of regulations. That's great, but how that is to happen and on what regulations, there's just no clarity, no certainty whatsoever. And this is a government-wide problem, because we, as regular MLAs, we've heard from Indigenous governments, we've heard from NGOs, we've heard from business, industry. They all want to have the opportunity to comment, and at least at a minimum, comment, maybe co-draft in some cases, as Indigenous governments are entitled to, develop these regulations. But there's no approach from this government, nothing. So this is an attempt to try to fill that gap and provide at a minimum floor for the ability for interested persons to comment on regulations. So I don't really understand what the problem is here, other than this is a government that is afraid to have a requirement for some kind of notice and public engagement, a requirement on the development of regulations. The problem with most of this post-devolution legislation is that virtually all of the details are to be hived off into some kind of regulation-making process that is a complete mystery, even to the department itself. So I know that the minister is not going to concur with this. I think that's a very big disappointment. It's not in keeping with the open government policy, an initiative of this government that was developed by the exact same minister. So I have a funny feeling this is going to come back to the floor of the House as well, because our government has failed to develop a government-wide approach to address the concerns of our citizens, our Indigenous governments, and the public. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Mr. McNeely.
Thank you, Mr. Chair. This is I can't see myself, in the spirit of the institution governance, I can't see myself supporting this. It may seem that it was a plebiscite request to have regulation co-drafted by everybody. We represent people of the Northwest Territories. In the opening comments, we engaged with 7 communities out of 33, and we had written submissions by some others. Is that 100% giving you confidence on a plebiscite that everybody wants co-drafting? I don't think so. So in the spirit of balancing and having governance, and we right from the get-go of these pieces of legislation, I knew that in every negotiation, you're never going to accomplish your targets that you've set. If it's 10, you'll never achieve that, but you can try. And this is an example of where personalities or people or the progress doesn't agree. We live in a multi-area with various regional governance. We've got 60% of our area under a jurisdiction of 4 land claims. Outside of that, we have 2 reserves. So there's various governance out there. So we have to have a balance of guidance and direction and leadership. And we have a multiple area of bureaucracy as it is. It's very hard to move in our areas. One area may not like development, the other may want development. So how do you draft legislation to accommodate that? I would prefer leaving that, setting the principles. The details are your regulatory authorities. And the guidance of this institution, I have faith, will take us to compromise in the recognition of those surrounding people that we represent out there in those various claim tenure arrangements. So that's my comment. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
No, we do not.
The minister does not concur with the amendment. The amendment will not take effect as a result. New clause 61.1 will not be added to the bill. Does committee agree now to return to the bill number and title? Committee agree? To the bill number and title, Bill 46, Public Land Act. Does committee agree? Thank you. The bill as a whole as amended, does committee agree? Thank you. Does the committee agree that Bill 46, Public Land Act is now ready for consideration in committee of the whole as amended? Mr. McNeely.
Thank you, Mr. Chair. I move Bill 46, Public Land Act, be reported to the Assembly as ready for consideration in the Committee of the Whole as amended and reprinted. Thank you, Mr. Chair.
Thank you. Motion is in order. To the motion? Question has been called. All those in favor? All those opposed? Motion is carried. Bill 46, Public Lands Act, will be reported to the Assembly as ready for consideration in Committee of the Whole as amended and reprinted. I want to thank you, Minister, and thank you to your officials who have joined us here today. Do you have any closing remarks? Minister Siebert.
I'd just like to thank everybody for the tremendous amount of work that was done on this. There were some proposals, amendments that were difficult for us to swallow, but in the desire to get this done, and I think it is important that it does get done. And I know how much time pressure everybody's been under, that I was glad that in most cases compromises had been worked out, and I'd like to thank you again, and I hope I won't be hearing from the Muskrat lobby. Thank you.
Thank you, Minister, for your closing remarks, and I just want to thank everyone for coming here again this evening, and with that, we can be adjourned. Thank you.